China hold positive talks on border management, preparing for a Doval Wong meeting in India later this year. AIADMK General Secretary Edappadi K. Palaniswamy met Union Minister Amit Shah to discuss various issues concerning Tamil Nadu. He emphasized the continuation of the two-language policy. Kerala Chief Secretary Sarda Muralidharan writes in her Facebook post on the discrimination she faces due to her skin color and gender. Comedian Kunal Kamra seeks a week to appear before the Mumbai police over Eknath Shinde's joke row. US secures agreements with Ukraine and Russia to pause attacks at sea and on energy targets. In exchange, Washington agrees to push for lifting some sanctions against Moscow. At least 18 people have been killed and 19 injured as South Korea's wildfires continue to ravage the country's southeast. Very good afternoon to you, ladies and gentlemen. Welcome. You're watching News 9 and I'm Sriya Kundu here this hour to bring you all the latest updates and the top stories from across the nation and around the world. We begin this bulletin as we just took you through some quick headlines. However, the top focus of this bulletin is on a historic SC ruling that's come in. In a significant move, the Apex Court of India has stated a controversial order by the Allahabad High Court that sparked widespread outrage. Now, what they have done is they have stayed this very controversial order. Yes, the High Court had in fact ruled that acts such as grabbing a minor girl's breasts and breaking her pyjama strings did not constitute an attempt to rape. Supreme Court bench comprising of Justices B.R. Gavai and A.G. Masih initiated a suo motu case after the judgment was brought to their attention by the very organization We the Women of India. The court expressed strong disagreement with the High Court's view, describing it as shocking and displaying total insensitivity and inhuman approach. Allahabad High Court had modified charges against two accused, Pawan and Akash, who were originally summoned under Section 376 IPC, rape, and Section 18 of the POCSO Act. Now, instead, the High Court directed that they be tried under the lesser charge of Section 354B IPC, assault with intent to disrobe, that is, along with the Sections 9 of 10 of the POCSO Act. Now, we'll take you through some of the key observations made by the Supreme Court of India on this very matter, where they have clearly said that the HC order showed total lack of sensitivity. In fact, the Solicitor General Tushar Mehta has also concurred with the similar views with the bench of Justices B.R. Gavai, and what we understand is that the Supreme Court's decision as well, stating that there were sufficient grounds to stay the order. The court noted that the High Court's observations were not made on the spur of the moment, but after due consideration, making that even more concerning at this point. In fact, Tushar Mehta has said that this requires the HC chief's interference and intervention because it is a rather serious matter. Now, the Supreme Court has issued notices to the Union Government, the Uttar Pradesh Government and the parties involved in the case. Attorney General and Solicitor General has been asked to assist the court in addressing this matter comprehensively, and this decision comes after a significant public outcry against the High Court's ruling. Supreme Court's intervention highlights its commitment to ensuring that such serious offences are indeed treated with the gravity that they deserve. With that, we are being joined by Rekha Agarwal, advocate of the Supreme Court and women's rights activist. Ms. Agarwal, thank you so much for speaking to us at News 9. And today, indeed, while the Supreme Court's order reinstates our faith in the judiciary, but in the very first place, an order of the kind that we had witnessed that was delivered by the Allahabad High Court, it is concerning to say the least.
You're absolutely right. Just about, I think this came last week, this judgment by the Honorable High Court Judge of Allahabad. And I think the whole nation was totally appalled and shocked to hear, because this, in layman's language, I mean, there would be no doubt as to the kind of relief that the High Court granted to the accused in this particular case. And as you rightly said, that the Attorney General has, while commenting upon the High Court order, said that it was not a on the spur observation of the High Court judge, while passing this judgment, because he had the entire record of the trial court before him. In fact, if I may just place on record some of the facts which make the observation of the High Court even more appalling, and letting go these criminals, I would say, and letting them go of a very lesser charge, was that these two accused persons were being tried by the Sessions Court for the charge of rape and the POCSO also. And these two people had appealed against that. These two accused people had appealed against the framing of the charge itself. So when the High Court was seized of the matter, the High Court judge has gone to the entire material, that is the inquiry that was conducted by the police at the time of the charge sheet before the Sessions Court. So therefore, the High Court had sufficient material to examine before it. It was an onerous task. And having gone through that entire bunch of papers which the High Court, with the police must have filed by way of a charge sheet, I am shocked at how could the High Court judge come to such an insensitive and, I would literally say that hair-splitting decision. Said that this does not amount to he has drawn a very difference between preparation and intent. The High Court has said, well, they may be preparing to rape the girl, the victim, but they had no intention to rape. Now, I do remember very well that last week when I was speaking on another channel and I had to listen material before me, that these two accused persons had groped her breasts and had also untied the pajamas, and after that pulled the victim into the culvert. Now, if the victim had been pulled into the culvert, which is a matter of the trial court record, this is not something which is just in the air. So therefore, when you drag a girl, and that to a girl child, under the culvert, what was your intention? Okay, very well, you had prepared for a crime, and the intention is clear when you have dragged her into the culvert. That means you have, from step 1, you have gone to step 2. And the only thing which saved the poor child was a cries which some bystander heard and came to the rescue of the child. If the bystander had not come to at that point on hearing upon the cries of the victim, these two accused would have definitely succeeded in their intention to commit the crime of rape, and that too of a minor child. So I think that it was high time. In fact, I was waiting for the day. In fact, as an officer of the court, myself as a lawyer, and as a citizen of India, I am proud of the Constitution, that saves us from such kind of judgment. And thank God we have got a 3-tier system, the lower court, the High Court and the Supreme Court, where any judgment which is passed by any particular court by lower court can come under review of the High Court as well as the Supreme Court. Having said that, I think that this again reinstates the fact that the Supreme Court is not a silent spectator to what is going on in the higher courts, and it has suo motu taken cognizance of the fact that this was a very, very insensitive judgment passed by the High Court of Allahabad, and it has rightly stayed the order and issued summons to the concerned parties. As I just pointed out, that and that such kind of insensitive judgments need to be stayed. And I'm reminded of a similar order passed about 2 years ago by the Mumbai High Court. And what was most shocking to my conscience was, being a woman, that judgment was passed by a lady judge of the High Court of Mumbai, where a POCSO accused had been granted bail only on the ground that he had groped the breasts of the girl, not from under her clothes, but from above the clothes. So therefore, in that case, the High Court had, the lady judge of the High Court of Mumbai had granted bail. And
absolutely. Ms. Agarwal, we are a little short on time here, so I'll start with my next question. I'll just interrupt you there. I'm extremely sorry. But at a time when we are, and firstly, the fact that the Supreme Court taking this very step of staying the order at such a later stage in the case, that is what also makes it quite, that is what reinstates one's faith, because this is not the course, the legal course that usually takes. It's a little unusual that the Supreme Court stays the order at such a later stage. But yes, definitely that's a big win for us as Indian citizens. But at the same time, the messaging that was sent out by the Allahabad High Court and its verdict, at a time when we are already speaking of whether we need to review our rape laws that are already existent to make it a little more stricter, to make it more stringent, so that people out there in the society who are criminals and accused in such cases get this message that yes, the law will take its course. At such a time we see this kind of a verdict coming in, that also needs to be reviewed. What would you say should be done in terms of a probe that might be launched maybe into what exactly went behind in announcing this very verdict by the two judges of the Allahabad High Court? Would you say that is also another path that they should consider?
By the High Court or the Supreme Court?
By the Supreme Court, in terms of what should their procedure be in handling, and what should they do with the two judges? How should they handle and deal the situation in terms of the judges also, who in fact ended up giving that verdict?
I think that, you just mentioned about the rape laws, whether they need to be reviewed. Definitely not. I do think that post Nirbhaya, whatever amendments that have been made, in the year 2013, and the definition of rape has been made so wide that any such action that has been committed by the two accused in this particular case definitely comes within the parameters of the definition of the term rape. So as far as the review of the laws are concerned, I don't think that any such further review or further modification is required. The laws are good enough post Nirbhaya in 2013. The criminal amendment law is absolutely foolproof now, and it only needs proper application. And as far as the Supreme Court judgment today, the observation of the Honorable Supreme Court, the two judges have observed, I think that they have stayed the order. And as far as the High Court judge who passed the order is concerned, I think that the Honorable Supreme Court may possibly think of giving some our judges need some workshops in gender sensitization,
right.
And so they now understand that when a heinous crime of such sexual offences is concerned, they cannot just go straight by compartmentalizing the action of the accused person. The entire crime has to be seen in a broader perspective. And I think that workshops or some more on the ground knowledge of the law is required.
Right.
I think a little homework by our judges would come in good stead.
Absolutely, to sensitize the judges as well in matters of this sort, as to how to deal with matters of this sort. Definitely, Ms. Agarwal, thank you so much for speaking to us at News9 on this rather crucial judgment that's come in from the Supreme Court, staying the Allahabad High Court order on an attempt to rape case. Now, with that, we are moving on to a political story at this given point. The push to strengthen the ND alliance in Tamil Nadu has intensified ahead of the assembly elections. Now, AIADMK General Secretary Edappadi K. Palaniswamy met Union Home Minister Amit Shah in Delhi, sparking speculation about a possible revival of ties between the BJP and the AIADMK ahead of the Tamil Nadu state elections in 2026. Senior AIADMK leaders SP Velumani and KP Munusamy also travelled to Delhi, adding to the buzz of forming of an alliance. Now, the meeting comes amid growing speculation about the AIADMK reconsidering its stance